Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As if you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's case, we're dealing with a qualified immunity decision with a cop, but the qualified immunity concerns the cop murdering a dog, and it's not his first time, incidentally. This is the case of Christiana Bullock versus City of Detroit. In this case, the City of Detroit has a police officer who seems to have a bit of a track record when it comes to shooting dogs. And he shot this particular dog, and he shot him in particularly weird ways, and we need to figure out if we can sue the City of Detroit. So we're going to figure out if we can sue this guy for the shooting of the dog. Let's get started with this. The Detroit Police Department Major Violators Unit specializes in drug cases. Officer William Morrison, a member of the unit, has participated in more than 3,000 drug raids. During these raids, he has shot about 80 to 90 dogs. We lost count. This case, like another we recently decided, concerns one of these 80 to 90 dogs. So, yeah, it's Officer Morrison over here shoots the dogs on a fairly frequent basis. So, there's that. Okay. On September the 2nd of 2015, Christiana Bullock took her granddaughter to an amusement park. How nice. The same day, the Major Violators Unit executed a search warrant at her home following a controlled drug buy there 2 days before. The unit found no drugs, and Bullock was charged with no crimes. Yet, Officer Morrison shot and killed Bullock's dog, Mandy. Mandy has paid the price in the drug war, despite the not lack of drugs. So let's figure out what went wrong. Bullock lived alone with her dog Mandy at her home in Detroit, Michigan. On August the 31st of 2015, a confidential informant told Officer Castro and his partner that individuals were selling drugs at several locations, including Bullock's home. This informant had given information to the Major Violators Unit at least 10 prior times, which had led to 20 drug-related arrests and the seizures of drugs and firearms. Castro thus considered the informant reliable and arranged for a controlled buy at Bullock's home. After giving the informant $10 or $20 for the transaction, Castro and his partner monitored the buy from an unmarked car parked a few houses down the street. Castro walked as the informant walked to the home, interacted for 1 or 2 minutes with an adult male who came to the door, and returned to Castro's car. Castro did not see the exchange of drugs for cash, but the informant came back with a folded lottery ticket containing a substance that looks like heroin. So, we have this confidential informant. He's come through us before in the past. He says that this is a drug den. The police set up a controlled buy. They watch him go to the house, and he returns with something that appears to be drugs. So the police think, okay, this is a drug house. All right, let's read on. On September the 1st, after confirming the substance was heroin, Castro used the controlled buy to get a search warrant for Bullock's home. His affidavit expressed belief that the informant was reliable and discussed the user's prior experiences with the informant and resulting arrests and seizures. It also described the controlled buy, noting that Castro observed the informant go directly to the target location, stay a short time, and then return directly to Castro. A magistrate judge issued the warrant. The next day, 7 members of the Major Violators Unit executed the warrant. The officers knocked on the door and announced their presence, but no one answered. After an officer rammed the door, Morrison entered with Castro immediately behind. Both officers carried shotguns. Up to this point, neither Castro nor Morrison had ever seen evidence of a dog. So the drug raid is going well. The people in the house are not there because they're at an amusement park. And the cops show up, and the 2 cops in our story have shotguns. And they apparently didn't see or hear a dog up to this moment. So there was no signs of dog. And they bust into the house. What happens next? Just before or just after entering the house, Morrison saw Bullock's dog Mandy about 12 to 15 feet away. He thought the dog looked like a pit bull, but Bullock claims Mandy was a Labrador Retriever, which incidentally don't look that much alike, I'd like to point out. According to Morrison, the dog barked, showed her teeth, and charged, snarling. Morrison yelled dog and fired 2 shots at Mandy, presumably with the shotgun that he was carrying. Castro, who was covering Morrison's 6, did not recall whether he heard the dog bark or growl and did not see the dog, but he heard Morrison shout. Morrison noted that the dog squealed and escaped to the basement, leaving a trail of blood. Morrison and another officer eventually reached the basement, where again, according to Morrison, the dog stopped crying and started barking. Morrison said that Mandy approached the officers kind of limping, and because the first 2 shots didn't do the job, he fired 2 more shots, this time killing the dog. Okay, so this is a series of things that's happening. So Morrison over here enters the house, and the dog, who's either a bulldog or a Labrador retriever, because we can't tell the difference, starts barking and maybe charges. And so Officer Morrison here shoots the dog twice with a shotgun. Now, apparently, this didn't kill the dog, because the dog was able to run away to the basement in a trail of blood. So that's good. And Officer Morrison here then decides to go down into the basement and observe this dog limping with limping from the shotgun blast, and then decides, I still feel threatened, so I'm going to shoot this dog 2 more times with my shotgun. End of dog. That doesn't seem at all excessive or questionable in any way. Maybe getting the dog some kind of help would have been good, but it's coming right for us Jimbo style. Shooting the dog 4 times with a shotgun apparently was the way to go in this officer's opinion. On the day of the search, Bullock had taken her granddaughter to Cedar Point, an amusement park in Sandusky, Ohio. They went to Cedar Point. I'm sure they had a fun time at the fair. The return is going to be less fun. When returning from the park that evening, Bullock received a call from her neighbor that her door was hanging wide open. She got home about an hour later to find her house in disarray. The shots from Morrison's shotgun had left holes in her bedroom door, dresser, and mattress, as well as in her basement walls and barn. Bullock realized the dog had been killed after speaking with neighbors who had heard the search and seen blood on her basement steps. She called the police. They came several hours later and told her, this wasn't a crime because we did it. We did it because we had a search warrant. That's a rough end of the day, ma'am. Bullock says that Mandy has never previously been attacked or charged anyone. The dog would run away from strangers, which appears to be at least partially confirmed with the limping to the basement. She has also never been convicted of a crime, was not aware of drug sales from her home, and has never called the police there before. Bullock, however, did catch someone she knew to be a local drug dealer cutting through her yard about a month or so before the search. So maybe the drug dealer is using her porch without her knowledge. Okay. When discussing the confiscated guns, and this is the real sad part for the Second Amendment people, when discussing the confiscated guns, Bullock asserted that one was her uncle's antique German Luger from World War II, and the other was a starter pistol for a relay race. She tried to get the Luger back, but both guns were destroyed. Well, this just gets better and better with every passing moment. The police find no drugs. They shoot the dog 4 times. Then they confiscate her uncle's antique German Luger. And then they destroy it. Kind of like the dog. This is not going well in Ohio, and this is not going well in Detroit here. You know, it's not going super great here. Castro and Morrison sought qualified immunity, but the district judge denied their request at summary judgment. On Bullock's probable cause claim, the court stated that Castro's warrant affidavit contained significant misrepresentations and/or omissions. Castro stated in his deposition that he watched the informant make a controlled buy from a car parked a few houses down, but did not include that detail in the warrant. So he didn't include that he was parked a couple houses down in the warrant. In addition, Castro's affidavit did not expressly concede that he lacked other evidence of drug trafficking at home, or that he had not conducted surveillance of a home before or after the controlled buy. So I just had this one thing and nothing more. When disregarding these purported omissions, the district court concluded the affidavit did not establish probable cause. So the district court says, well, this warrant is defective because you failed to say that you're watching it several doors down and failed to make clear that you were conducting a surveillance either before or after and had no other information concerning that this was a drug den, maybe not the most thorough warrant affidavit we've ever seen in our lives. So the district court says, okay, no probable cause for you, warrant's defective. The district court also rejected Morrison's qualified immunity request based on Bullock's excessive force claim. It recognized police may shoot a dog that constitutes an imminent threat from the perspective of a reasonable police officer at the time of the incident without the benefit of hindsight. Yet it held that a jury should decide whether Mandy posed this threat. While Morrison testified the dog barked, snapped, and charged, Castro stated that he did not see the dog charge or hear the dog bark or growl, but he heard Morrison say dog and fire shots immediately thereafter. So maybe Morrison is, padding the truth a little bit here. Not that a police officer would ever testify and pad the truth in any way. They are just straight brokers. They would never get on the stand or provide a deposition that was potentially misleading in any way. Okay, so now having reviewed what the district court said, the Court of Appeals must consider these two issues in turn. The probable cause determination and the excessive force claim. Was there sufficient probable cause? Was there excessive force? What should be done with qualified immunity? So let's consider those, first dealing with the probable cause and the standards that apply. The Fourth Amendment protects the right of the people to be secure in their houses against unreasonable seizures. Given our common law tradition of treating the home as first among equals, or to put it another way, the home is special, the Supreme Court has interpreted this language generally to require a warrant for searching of a private residence. That requirement in turn triggers another Fourth Amendment command. No warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and things or persons to be seized. If officers search a person's home based on warrant issued without probable cause, a person may seek damages under 1983. To avoid qualified immunity defense in this setting, the plaintiff must show it is obvious that no reasonable competent officer would have concluded the warrant should issue. Put differently, an officer's reliance on magistrate's probable cause finding must not just have been mistaken, but plainly incompetent. So once the warrant issues, an officer can rely on it. It is a decision from a court, after all, and it's a decision. So when we're talking about the reliance on the warrant, not necessarily the issuance of the warrant. So there's two different things you have to consider here: the issuance of the warrant and the reliance on the warrant. So if you're an officer completely uninvolved with getting the warrant, and the warrant is just given to you, you can rely on what it says. So then the only reason you'd be held liable is if you were not just mistaken, but plainly incompetent. So you'd have to look at the warrant and say, this doesn't make any sense. So you have to, and also in face of a judge's decision to the contrary. So as you imagine, they get quite a lot of latitude. And then there's a different thing with the issuance of the warrant based on false representations, but we have to consider those separately. So in the case of reliance, it has to be only if it is plainly incompetent, that no reasonable officer should have relied on it. Unable to show a violation of clearly established law based on the affidavit contents, Bullock turns to a different argument. She contends Castro recklessly omitted facts from the affidavit. First, a plaintiff must present substantial evidence proving that a testifying officer did more than negligently include a false statement or make a material omission. So it has to be more than negligent. It would have to be at a minimum reckless, and probably more than that, to be quite honest, knowingly. The plaintiff instead must show the officer stated a deliberate falsehood, otherwise known as a lie, or showed reckless disregard for the truth. When a claim hinges on alleged omissions, however, the mere existence of omissions alone is ordinarily not enough to make this strong preliminary showing. So, omitting things is not the same thing as stating lies. They're evaluated differently. The plaintiff must show the alleged false or omitted information was material to the finding of probable cause, meaning a judge would not have issued the warrant without the allegedly false material. So that is the big end of this conclusion. That's the big end of this thing at the end of the road. Did it matter? Did it matter? Did the officer? So yes, that means quite literally the officer can lie to the court or the officer can deliberately omit facts from the court. So that's a thing that they can do. The only question is, did it matter? So if the lies don't matter, they don't count. So, go nuts as long as it doesn't matter. So if you remove all the lies and you put in all the omitted things, would it change the issuance of the warrant? Did it matter? That's the legal standard. Fine. Bullock cannot get past the first step. She argues the one sentence in Castro's affidavit was misrepresentation. Castro stated that he observed the informant go directly to the target house, stay for a short term, and return directly to Castro. Her ground for thinking the statement was a falsehood? She argues the affidavit omitted the location from which Castro watched the informant. In his deposition, Castro clarified he was parked a few, maybe 3 or 4 houses away during the buy. According to Bullock, the omission of this location from the affidavit was material, because unless he had parked the vehicle directly in front of a residence, it was impossible for him to see what, if anything, transpired at the door. Yet Bullock cites no evidence to support this argument that Castro could not see her from the front door, where he was parked a few houses down. So, this argument's not going to really work, right? Even if you're 3 or 4 houses down, you can observe the front door. I mean, it depends obviously on the setup of everything. So, if there's a tree in the way or bushes in the way or something, whatever. But you can probably with the naked eye observe it, and certainly with any kind of binoculars. You can see what's going out the door. Enough to see that someone goes up to the door and talks to someone for a couple minutes and looks like someone's exchanged, and then they come back with something that looks like heroin that later tested as heroin. So, can you observe that from 3 or 4 houses away? Probably with the naked eye. Definitely with observation equipment. So, this fact being omitted is not going to change the analysis. He observed these things, and okay, so mentioning where I observed it from wasn't going to change the analysis. The rest of Bullock's alleged omissions were not omissions at all. She states that Castro's affidavit failed to expressly concede he lacked other evidence of drug dealing at her home, including that Bullock's home had no history of drug trafficking, Bullock was not a known drug dealer, confidential informant had not observed a prior drug transaction at the home, the informant had not been inside Bullock's home or seen drugs there, that Castro had not conducted additional surveillance, or Castro had not attempted to arrange a second control buy. True enough, but Bullock identifies no case indicating a police officer makes a recklessly misleading omission by failing to include concessions of all the additional investigatory steps that an officer might not have taken, but did not. Yeah, that's also a fair statement of law. There's an infinite number of things an officer could do before they, reach the conclusion, right? There's essentially infinite many steps. So there's all number of things they could have done. But are those things necessary? No, you only have to get to probable cause. Now, if you happen to discover something that gets you back below probable cause, you have to factor that in. But once you get to probable cause, you're there. So he has a witness, he has an informant who's proven to be reasonably reliable, so we can rely on this witness, this informant, who says drugs are being stolen there. Okay, so he sets up the control buy, he observes his informant, go to the house, talk to a guy, return with something that looks like heroin that tests as heroin. Okay, so is that probable cause to believe the drugs are being sold from the house? Yeah, I mean, based on those facts that we're being told, it is. Now, there's a whole bunch of additional steps he could have taken, but he doesn't necessarily have to take those steps, and these facts doesn't change the probable cause analysis. And there's many facts that you could put in that would, that would maybe counsel the other way, but that's not the standard. You just have to give enough to a probable cause standard, which I'd like to remind everyone is pretty low on the totem pole. The probable cause on a scale of 1 to 10 is probably 1, maybe less. So it's not a lot. So is this probable cause? Yeah, I mean, yeah, easily. So the warrant is not defective. However, the warrant not being defective doesn't teach us anything about the excessive force claim and the shooting of the dog. Just because the police had the permission to search the house for the drugs, which incidentally they didn't find, doesn't mean that they can do anything once there. So having determined the warrant was proper, now we have to determine whether excessive force was used. Did we do it bad by shooting the dog? Let's find out. An officer's use of deadly force against a person's dog qualifies as seizure. The critical question thus becomes whether an officer's use of deadly force against a dog was unreasonable. We've held that an officer's use of deadly force against a dog while executing a warrant to search a home for illegal drug activity is reasonable under the Fourth Amendment when Given the totality of the circumstances and viewed from the perspective of an objectively reasonable officer, the dog poses an imminent threat to the officer's safety. On the one hand, Officer Morrison stated in his deposition that Mandy barked, growled, and charged, snarling at him, and the officers breached Bullock's front door. He adds that Bullock did not witness the officer's search and that he provided only eyewitness account of the charge. Morrison would be entitled to qualified immunity under his version of the facts. His conduct would have comported with the Fourth Amendment even without qualified immunity because the dog would have posed an imminent threat to the officer's safety. On the other hand, Bullock relies on circumstantial evidence to argue that Mandy did not bark, growl, or charge, snarling at Morrison, and yet Morrison shot the dog anyway. Among other things, none of the officers had heard or seen Mandy when they shouted their presence and gained entry by ramming at the door. In addition, taking the facts of the life most favorable to Bullock, Castro did not see her or hear her, Mandy, before Morrison shouted and shot the dog. And while Morrison shot Mandy a second time, he concedes the dog was limping. So, how much threat could it possibly pose at that moment? More generally, Mandy had never previously charged anyone and typically held from strangers. The district court held that Bullock's circumstantial evidence created a genuine issue of material fact over whether Morrison acted unreasonable in shooting and killing the dog. That is, over whether or not the dog charged him. Besides appealing the district court's finding about disputed facts, which you can't do in an interlocutory stage, Morrison ends with a purely legal argument. This should be good. He asks us to hold either that Bullock's unlicensed dog was contraband and thus unprotected by the Fourth Amendment, or that Morrison is held to qualified immunity on this basis. So that's just a nice little kick in the teeth. So apparently, for whatever reason, I don't know how this works, but apparently the dog is unlicensed. And so Morrison over here wants to say, aha, the dog is unlicensed. That means the dog is contraband. So I could seize the dog because it's illegal. So shooting it is no big deal. What a kick in the teeth, man. Yet no matter how we would approach this as an original matter, we've rejected this argument similar times for 3 different times. None of the unpublished decisions is binding, Morrison responds, but he offers no new support in the position. We see no basis. We thus affirm in part, reverse in part, and dismiss in part for lack of jurisdiction. So qualified immunity for the search, not so much for the excessive force. Let's go back to trial and see what we want to prove to a jury. Thus, that brings us to the end of the case of Christiana Bullock versus City of Detroit and William Morrison. In this case, William Morrison is a dog shooter. He has shot between 80 and 90 dogs in his travels as part of the City of Detroit Police Department. He likes the shooting dogs. He likes it to the tune of at least 80 to 90 times. And so, he did all that. And he shot this particular dog. And this particular dog, is not going really great there. And so we can see that this dog is dead and it was limping. We shot it again. So we had permission to search the house, but not so much on the shooting the dog the second time when it was limping, maybe. So go back to trial, figure out whether or not any of that's true. And at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.